The following case analysis will describe an issue occurring in Dunedin between an elderly tenant and his landlord, which will be presented by myself, Cooper, Edward, and Antonia. The elderly tenant spent his final weeks in a damp and mouldy rental property, which was denoted as dreadful and uninhabitable. The central issue to the case was an elderly tenant spent his final weeks in a dreadful and uninhabitable, mouldy and damp rental. The cause was from broken windows, leaking walls, and non-functioning appliances and a concaving roof. Ultimately, the Tenancy Tribunal ordered the landlord to pay $13,000 in damages. This presentation will cover the case facts and proposed property management solutions.
So we look at the timeline of the case. Beginning in 2016, the rental property started showing problems, including broken windows, a leaking roof, and faulty appliances that were never properly repaired. Next, the landlord cut communication and moved overseas, leaving tenancies with no management. A tenancies complaints officer noticed that Brown had been unresponsive to multiple attempts at contracts since moving overseas. The tenancy's daughter then moved in for the last 10 weeks of her father's life. She noticed the property poor condition, which didn't help her father's health issues. Her husband instead arrived and hazarded at their own expense due to the unresponsive landlord. Tenants passed away short after. By 2023, the Tenancies Tribunal ordered Brown to pay damage for property management failure and breaching the residential tenancies acts. The tribunal found the property to be dreadful.
The main issues of the case are as follows. Firstly, the tenant, particularly the elderly resident whose health declined, was vulnerable due to their age and illness. The situation was exacerbated by the landlord's neglect, leaving the tenants in substandard living conditions without adequate resource or support. Secondly, the landlord breached the Residential Tenancies Act 1986 by not keeping the property in a reasonable state of repair and failing to appoint an agent while living overseas. This lack of compliance was a significant violation of the tenant's rights and the landlord's legal responsibilities. Next, the landlord exhibited a lack of engagement with the tenants and the authorities. He failed to respond to the Tenancy Tribunal's instructions and was unresponsive to communication attempts, demonstrating negligence in managing the property and addressing the tenants' concerns. And finally, the landlord failed to maintain the rental property in a habitable state, with significant issues like dampness, mold, broken windows, non-functional appliances, and a leaking roof leading to a collapsed ceiling. These conditions were not only dreadful, but likely contributed to the deterioration of the tenant's health.
The Tenancy Tribunal had four main points of this case. Firstly, the tribunal ordered the landlord.
My team and I had identified three key property management measures that could have helped prevent the negative outcome of the case. The con of this issue is the lack of a property manager. The landlord was unable to manage the property directly, especially when living abroad. Appointing a reliable property manager or agent is necessary. A successful property manager would do the following. Firstly, proactive maintenance culture for managing properties, especially when landlords are not present. Ensuring oversight and care the legal obligation and met. Secondly, correct training. Ensure that all property management staff are trained to recognize signs of neglect, poor living conditions, or health issues among tenants. They should also know how to respond appropriately. Lastly, tenant support, providing tenants with resources or information on assessing support service, such as legal advice or healthy service, can help address issues that may arise due to a property condition.
Proactive maintenance means maintenance to be addressed in a timely manner and in best case scenarios before the tenant is affected by it, as this is a requirement of the Healthy Home Standard. The landlord could have improved the situation through scheduling inspections between the times of 8 a.m. and 7 p.m. with a notice of no less than 48 hours and no more than 14 days, which would have allowed the damage to be assessed and fixed. In this case, the roof could have been assessed and repaired, ensuring that it wouldn't have collapsed later on, also preventing the mold problem. When looking at the Residential Tenancies Act, Section 45, subsection 1A, The landlord has a responsibility to provide and maintain the premises in a reasonable state of repair. Here, the landlord most definitely did not provide reasonable maintenance or reasonably repaired the property as they were absent, harming the tenant and the property's condition.
As a landlord, being present and approachable is crucial to ensuring tenant comfort and safety. It is also beneficial for maintaining occupancy and ultimately building trust and communication. The renting community is a diverse demographic ranging from young adults to the elderly pensioners. Due to this, accessibility is imperative. Landlords can achieve this by providing resources and support amenities like legal advice, health and disability services, and points of contact. Catering to elderly tenants' health is critical. One way to ensure the elderly's safety and well-being is to conduct routine welfare checks. This way, landlords are aware of their tenants' health conditions and can be prepared for any changes. Operating an accessible and approachable rental is increasingly important as home ownership is harder to achieve in today's society. By doing so, landlords can mitigate issues in a timely manner and ensure tenants are living in a safe and healthy environment. To address the case, it's evident that Brown had no rapport with his tenants at all, as he did not offer any points of contact since 2022 and was not even active in the hearing process. After reviewing the facts, it's clear that Brown was not an approachable landlord and provided no accessibility services or resources. If Brown had been a lawful and approachable landlord, he would have avoided any legal problems resulting from poor property management and risking his tenant's life.
Ensuring all property management staff are trained to recognise signs of neglect, poor living conditions, or health issues among tenants is crucial for maintaining a safe and supportive living environment. This training should cover the identification of key indicators, such as inadequate heating, plumbing issues, structural damages, and visible signs of tenant distress or declining health. Successful managers should be equipped with the knowledge and skills to assess these situations accurately and time-sensitively, understanding the potential risks and appropriate steps to take. This includes knowing when to escalate the issue by contacting emergency services, such as paramedics or fire departments, and in urgent situations reaching out to social workers and community support services for ongoing assistance of residential tenants. With reference to the case, a properly trained manager would have seen the signs of neglect, including the non-functioning appliances and the deteriorating roof and the lack of heating, which did not meet the basic requirements for humans to live, particularly an elderly tenant of declining health. Emergency services such as an ambulance or a social worker could have been brought in to prevent the issue from escalating to the extent it did. By fostering a proactive and informed approach, property managers can significantly enhance tenant safety and well-being while also preventing serious incidents such as in the instant case.
To conclude, the case involved an elderly tenant whose health deteriorated through issues such as a collapsed roof, broken windows, and non-working appliances. These issues have been predominantly caused by poor maintenance and management of a rental property. To remedy the situation, the Tenancy Tribunal ordered the landlord to pay the required amount as well as covering compensation for the filing fee and disbursements. When reevaluating the case, appropriate property management could have avoided the situation through the application of proactive maintenance, including regular inspections, timely repairs, and thorough documentation to prevent physical deterioration and ensure regulatory compliance. Secondly, training of property managers with skills to identify neglect, poor living conditions and health issues, and the capability to engage emergency services or social workers. And lastly, through providing tenant support by offering resources and information for accessing legal advice, health services, especially for elderly or disabled tenants, to foster strong relationships.